Welcome along to the next instalment of our video series, the Renters' Rights Bill Landlord Survival Guide. It's powered by Title Guardian, and I am joined once again by solicitor David Smith to talk about how landlords can plan and survive and even thrive under the new legislation. And David, really picking up from where we left off last time, we know that a lot of landlords in the UK are what are often called amateur landlords or dinner party landlords. They have
dinner party landlord. Well, that sounds really good. I like that title. Everyone should be one of those.
But they've got one or two properties. They're on the back burner as a pension hedge or a legacy for their kids. They've got a career. Maybe somebody like yourself, who's a solicitor, professional person, has a few buy-to-lets. They don't kind of think as a landlord in many instances, but they are the mass landlord market in the UK. I think 97% of all landlords in the UK are 3 properties or less. I'm quite concerned for them because they're definitely going to have to start operating more professionally and raising their game and actually treating being a landlord like a business, aren't they? Yeah, and I think to be fair and say that the government kind of wants them to do that or leave, and it was the policy of the previous government to some extent to discourage accidental landlords, and I think with the policy, it's very much the policy of the current government to do so, and this bill does do so. And then also because of increased cost base and so on, and the challenges of making an operating profit, being an accidental landlord and just renting out the house you inherited off your grandma or the house you kept when you got married may not in fact be the best business strategy. Landlords, I think, who are serious about this will have to effectively profit seek and really hunt for properties that are going to maximise their profit potential, and that may not be the properties that you currently have. So that does change the game. It does require a great deal more thinking, and I suspect that some of those dinner party landlords, I'm going to use that phrase, dinner party landlords, might be best advised to sell up and put their money into the stock market, or alternatively find a new agent who's able to really deal with their portfolio effectively for them, or join a scheme that group invests for rental property. There are an increasing number of those, or something else. Or alternatively give up the day job and do full-time dinner parties and landlording. Well, if they choose the option to sell up, but they probably want to do it before the Renters' Rights Bill comes into force, because and lots of people are. I mean, I should be clear about this, that there is definitely an aspect in which in some areas quite a lot of landlords are selling, for sure. Yeah, because once the Renters' Rights Bill comes into force, it becomes actually much more onerous to sell a rental property. Could you just talk us through the process that will be in place with the Renters' Rights Bill? Yeah, so obviously you can't serve a Section 21 notice because they don't exist. So if you want to sell, there is a ground for possession specifically because you intend to sell, but it has consequences. You can't use it for the first 12 months of somebody's occupation in your property. So there's a lockout, but then you have to give 4 months notice. And as soon as you've given that notice, there's then a 4-month plus 12-month, so a 16-month lockout period when you can't put the property back on the market. So if you take the property off a tenant and evict them in order to sell it, and you can't sell it, then you can't re-rent it either. And therefore, in practice, you're going to have to sell it at any price. And the point to note here is that quite often when landlords sell, they have a significant hope value added into their price that it does not necessarily reflect the market value. And so my general position to landlords on this is, if you're intending to sell, you really need to mean it about the sale, and you need to have gone and investigated market pricing and price your property at a price that's going to sell. Otherwise, you'll be sitting with a vacant property. And you might wish you had in fact taken that offer that you thought was a bit low anyway. I think, we may see an increase in the landlord to landlord sales market to kind of avoid the void and the potential falling through of sales and things like that. So in a way, that's actually quite a positive thing, I think, because the tenant can remain in their home and the property stays in the private sector.
Yeah, I mean, there's been lots of attempts to create that and to encourage that in the past, and they've never been successful for kind of two reasons. One, if you sell it with vacant possession, you open up to a wider market segment.
You might get a higher price.
And you might get more money. And then also, finance is more difficult to acquire when it's a landlord-to-landlord sale. But subject to finance companies making it a bit less onerous or a bit easier on this regard, yes, I think it's certainly a possibility that landlords will look to sell to landlords if they think they can get the right price.
Okay. Now, there are some new requirements and memberships that landlords will need to adhere to, and if you're not compliant, then you'll struggle if you do want to gain possession of your property. Could you just talk a little bit about those two issues?
So landlords will have to join landlord redress schemes in the same way that letting agents have to be a member of redress schemes. Landlords will also have to be a member of redress schemes, so there'll be two for some landlords. And landlords will have to join the PRS database, and there is a fee for both of those things. You will get a registration number which must be put on your advertising in the case of the redress scheme. It has to be, or you have to have done these things before you can even market your property, so you can't do, for example, as many people do with gas safety certificates, market the property, then get the gas safety certificate just before the tenant moves in. You'll have to join before you can commence marketing. And if you don't do it, can't get your property back until you do. The tenant is entitled to seek a rent repayment order. You can be prosecuted, or alternatively, the local authority can come after you for a civil penalty. So again, quite an onerous set of circumstances. And again, the thing that really worries me about this is landlords who are out there now with tenants in place who will be, again, blissfully unaware of all of this stuff, and will then find themselves with some unknown time period to join up and miss all of it. And then the other thing that I would warn people about is make sure you know who the landlord is. I mean, that sounds like an obvious point, but what you've seen in Wales with the Rent Smart Wales scheme is that you've got some landlords who own properties in their name, or jointly with their spouse, or in a limited company, or in a trust that's ultimately giving money to their kids, and they operate them all as one undifferentiated whole. But those are all different registrations for the purposes of a redress scheme and a PRS database. And you'll have to register each of those entities separately, as legal entities separately, and make sure the right properties are stacked into the right entity. And that's been a problem in Wales, and people have been prosecuted for not getting that right. So it is important to just bear those points in mind as well. What the government has also intimated, though, is it's almost going to be a landlord checkup tool, and it will allow tenants to see whether landlords have been civil penaltied or prosecuted. And for those very small number of landlords who are rogue landlords, they will be on that as well. So, it becomes increasingly important not to get a civil penalty, because your tenants will be able to look you up. And the government hopes, whether it will make a difference, the government hopes that tenants will vote with their feet and choose not to rent from particular landlords. Now, in practice, they probably won't, because there's not enough properties for that choice to be made. But certainly, tenants who have a bit more money and a bit more choice and are a bit better may choose to vote with their feet. So if you've got civil penalties, the reality is you'll be attracting less attractive tenants who are less fussed about this stuff or more desperate. And that can't be good for your business.
Well, I'm sure, responsible landlords won't have a problem with non-compliant landlords, being exposed, so to speak. So in some ways, that is a good thing. We've been talking about how landlords can plan for the Renters' Rights Bill. A lot of landlords, trundle along with their rents below market rate because they've had the tenant for a long time. Some landlords only put up rents between tenancies. I'm one of those landlords, actually. So there'll be landlords heading into the Renters' Rights Bill on a below market rent. They might want to think about raising the rent prior to it coming into effect, because once it's in effect, it's a lot more onerous to raise the rent, isn't it?
Yeah, so that there is no rent control, as the government is quick to say, but there is a structure which certainly suppresses rents and slows down rental increases. So you can only raise the rent every 12 months. The only way you can do so is by way of Section 13 notice. You can't put a clause in the tenancy agreement. You can't make an agreement with your tenant. You must serve them with Section 13 notice to raise it to a market level. Once you've served that notice, you can make a written agreement with your tenant to increase the rent to a number less than the Section 13 notice. But the tenant then has, in any event, has 2 months to contest your increase to the first tier tribunal, which happens now, but not very much. And the first tier tribunal then assesses your rent against the market. They can't go above the number that you put on your notice, but they can go down. And then the rent increase kicks in from the first rent payment date after the tribunal makes its determination, which is unusual because at the moment, those are backdated to the date of your notice, those rent increases, but under the new system, of course, it's almost always in a tenant's interest to contest a rent increase because, okay, the tribunal may not reduce it, but it's free to apply to the tribunal and always has been for this purpose.
And it could take a while to get one.
And it could take several months for the tribunal to make a determination, so they put off the day. So I suspect what many landlords will do and probably should do is serve a Section 13 notice with a rent increase, but then try and agree a slightly lower figure with their tenant to get it done and to settle it out. But of course, this has a knock effect. It slows down rent increase. So the notice period is doubled as well from 1 month to 2 months before the rent increase kicks in automatically. So that slows it down. You've got this position where if you go to tribunal, it takes, tribunal says about 4 weeks, but my experience is it's a lot longer than that. And it will probably get longer still. And then, of course, your next rent increase is 12 months from whatever that determination date is. So it slows down your next rent increase as well. So it's got this process that it slows down in tenancy rent increases. Now, the government thinks they're a really big thing, but actually they're kind of not. I mean, rent increases happen in 2 situations. One on a renewal. Now, obviously, those won't happen, so that certainly changes that dynamic. And between tenancies, and of course, that's not controlled. And what will happen, I suspect, is many landlords will probably, in most cases, moderate their increases and go for between tenancy increases. But at the same time, if you say to landlords, well, you can only increase your rent every 12 months by way of Section 13 notice, and it will take some period of time, then certainly some landlords will respond to that by making sure they increase the rent every 12 months to a market level. So certainly landlords should be looking now to bring their rents up if they can to a market level to make sure they go into the Renters Reform Bill at the correct level. And then they'll need to decide whether they're in a position where they're prepared to let it ride and do it between tenancies, or whether they've got longer term tenants and are going to do it on a more frequent basis.
Okay. I think it's interesting, we talked in the previous video about the removal of Section 21, and landlords are often asked by tenants to serve them a Section 21 so that the tenant can access council and social housing. What's going to happen there? Because the tenants actually requested that kind of end of the tenancy.
I mean, the problem here is that was always a bit of a nonsense because more often than not, tenants who think they're going to get a council house probably aren't. The local authority might assist them into accommodation that better fits their budget, but there's a real shortage of social housing. Unless you're a priority need case, you're probably not going to get it. Now, of course, in principle, that's going to change over time as the government builds more social housing, but we're quite a long way from that happening. The government has said it's going to alter the guidance that local authorities have now as to what constitutes making yourself intentionally homeless from the point of view of a tenant. I doubt that tenant just giving their own notice to leave will fall within that criteria, and the reality is local authorities have ignored that guidance across the board for years and do something illegal that we call gatekeeping in the trade to discourage access to social housing because they don't have any to offer. And I don't think that will change, and the only thing that will really change that dynamic is an increase in social housing. And obviously the government has promised that, and I hope they can deliver on it.
Okay, well, final point, David. Damp and mould, very high on the agenda. AWAB's law being brought across from social housing into private sector housing. Landlords are going to have to be very on the ball about the condition of the property. I can see more use of inventories, mid-term property inspections, which I think are good and should be happening anyway. What else do landlords need to be mindful of in this regards?
Well, we don't know much about bail-ups law because the government says we have consultation and various obligations, but the general tenor is that landlords will be required to respond quite quickly to particular types of inspection reports. So I think it's more about, yes, being aware of what's going on in your property, but also being organised and structured in such a way that if a report is made, you're actually acting on it relatively promptly. You know, landlords who have good quality agents, it's not really a problem. Most good agents are on top of it. But I certainly come across cases where it's taken 2 to 3 months to even deal with a report. And, you know, that's just not going to be acceptable under the new regime at all. So it's more a case of if you're a landlord, having a structure in place to respond and kind of having some contractors that you can be fairly confident will get out and look at things and get things done. And agents are quite helpful in that regard because they tend to have the little black book of contractors, but landlords will have to find their own mechanisms if they're not using an agent to replicate that position.
Well, indeed, they can use reporting software.
There is reporting software.
And talking of software, obviously we're today powered by Title Guardian. Let's just remind everybody of the benefits of using Title Guardian as a landlord, because it is a specifically landlord orientated product. Yeah,
so Title Guardian's great thing is you can upload your properties with it, and people might be familiar with using the land registry fraud tool, but Title Guardian takes it to a whole new level by taking into account the potential for people putting mortgages over your property in the land registry tool, but also checking to see if your property's been listed with another letting agent, where those guys are providing information, trying to check if your property's been listed on a short let portal, and a number of them are available, checking to see if people have registered companies at your address. So a whole load of actions that tend to speak to abuse or fraud at your property. And just great, you know, a fairly reasonably priced early warning tool for landlords to help protect what is their primary asset. And to be fair, probably the most expensive asset you own. So why wouldn't you? And
it's important because if it is a rent-to-rent scenario, it could be the landlord that you know is responsible for any rent repayment order if the subtenant stops paying the landlord the rent when the rent-to-rent tenants have paid the rent-to-renter, if you see what I mean. So you need to know. So
yeah, you may well face prosecutions and things like that, but leaving all that aside.
Yeah, you don't want subletting.
You're going to have to sort the mess out.
Yeah.
And it's always better then to pick these points up as early as possible and try and get on top of them. I mean, ideally, one of the great things Title Guardian do is actually tell you before someone's even occupied the property. And if you get in there fast, you can potentially nip it in the bud. And of course, your tenant will deny all knowledge this ever happened, but there's quite a lot of case studies I've seen from Title Guardian where landlords have jumped in quickly and the property's been delisted and the person has then sought to get out the tenancy, and they've caught it before it all went wrong.
Excellent. Well, thank you so much for your contribution on these videos, David.
Thank you.
We know you're right in the thick of it with the Renters' Rights Bill, so it's great to have you as part of our contributing team. And just to remind everybody that there is a downloadable ebook also titled Renters' Rights Bill Landlord Survival Guide, and you will find the link below this video. And we do invite you to download it, and you know, we'll be updating it as the bill progresses through Parliament, because obviously, as we've been saying, some things aren't set in stone yet. So we will be updating the ebook to reflect the true situation of the legislation as it moves forward through into statute. So thank you for watching, and I do hope you'll join me on another of these videos as this video series will be continuing.